handing out, Holly? Are you done? Ready to go? Okay. Welcome everybody and everybody who's on the phone. As you no doubt have followed, the Patient Protection and Affordable Care Act was signed into law last Tuesday. And in the immediate aftermath of that, I received correspondence first from the 8 Republican congressional representatives in the Ohio delegation on the same day, Tuesday the 23rd, and then the next day from the 21 Republicans, members of the Ohio Senate, in each case formally requesting me on behalf of the state of Ohio to join the lawsuits that have been filed to oppose the implementation and challenge the constitutionality of the Patient Protection and Affordable Care Act in federal courts around the country. I work with these individuals who have made this request on a daily basis. I have great respect for them. I thought that their formal request to me deserved a formal response. We have been reviewing the lawsuits and the claims that are raised in those lawsuits over the last several days, and I have reached my considered conclusion, which is that we believe that these lawsuits do not have any legal merit whatsoever. We will not be joining those lawsuits. The state of Ohio will not be joining those lawsuits, and that's our considered conclusion. Let me say that this is a matter of federal constitutional law. For myself, my background is that I clerked for 2 justices at the U.S. Supreme Court, Justices White and Anthony Kennedy. They were appointed respectively by President John Kennedy and President Ronald Reagan, both sides of the aisle. They taught me during my time there to review carefully challenges to federal laws under the Constitution and to respect the balance of power between Congress and the states. That's the same respect I have sought to convey to my students when I taught constitutional law at the Moritz College of Law at Ohio State for 13 years. And that's the spirit in which I have approached this issue, taking it very seriously because this is a matter of how to deploy the litigating authority of the state of Ohio, which is a significant weapon. I do not think that either the Commerce Clause challenge to the law or the 10th Amendment challenge to the law has legal merit. It would require tearing up decades of contrary precedent, which would require activist judges on a significant scale, which is something that the proponents of these lawsuits normally deplore. And I do not think that it would be an advisable expenditure of taxpayer resources on behalf of the state of Ohio. I can go into in more detail the precedents on which the Commerce Clause analysis is based and the 10th Amendment analysis is based. I'd be happy to take questions, but I will simply say that we have had specific priorities that I promised the voters in 2008 when I ran for Attorney General. The centerpiece of that was to work hard on the economic security issues affecting Ohio families. Things like foreclosure prevention, consumer protection, our Holding Wall Street Accountable project, which is the heart and soul of what we're doing here to protect Ohioans against the economic meltdown that started on Wall Street and has consumed many of their lives and much of their hard-earned savings. That will continue to be our focus in this office. This would be a distraction, and it would not be a good use of our resources in the Attorney General's office. So that's my conclusion. I'm conveying that in correspondence to both of those groups of public officials today. Those letters are available in your packages, and happy to take any questions.
General, what about
which would make statements in the Ohio Constitution about whether the Health Care Act passed by Congress would have effect in Ohio. There are issues about whether that is a constitutionally valid objection to a federal law in violation of the Supremacy Clause, but those are not my issues. As the Attorney General, my role on any constitutional submission like that is limited to, as an initial matter, determining whether the summary that they have submitted is a fair and truthful, fair and accurate account of the ballot measure. We are in the process of sizing that up, and that will not be influenced one way or another by any personal views that I or others may have of the merits of the provision.
On an emotional level, what would you say to the families here in Ohio who can't afford health insurance and are now facing a fine if they don't get it?
The purpose of the act, as I understand it, is to extend health insurance to 30 million additional Americans who did not have it before. I believe the estimate is about 1.5 million Ohioans. There are subsidies in the bill. There are other provisions that are intended to operate as a whole to make this system work for Ohioans. This is phased in. Some of it does not take effect until 2014, so we'll have a chance to see how it is working, and if there are adjustments needed, I'm sure Congress will consider those adjustments. But there are subsidies for people who can't afford health insurance. Right now, of course, there is nothing available to them, and they simply do not have health insurance, and they live every day fearing that they and their families will be ruined if they come down with an illness or they're injured in some way that requires expensive care, which could happen, of course, to any one of us any day, including today.
Is it fair to say you conclude that the federal law does not trample on Ohioans' rights?
That is fair to say. There have been two objections made to this. The first is that Congress does not have the power under the Commerce Clause to legislate affecting health care, in particular to require an individual mandate that people purchase insurance. There is no individual right in the Constitution not to purchase health insurance. This is not one of the fundamental rights guaranteed under the Bill of Rights. It is a manufactured, unenumerated right, and it's a fanciful argument, actually. The United States Supreme Court has made clear for 70 years, including very recently in 2005, not a 5-4 decision, a comfortable decision, that if Congress legislates on a matter affecting interstate commerce, even if the matter itself does not involve economic transactions, and an issue in that case, Gonzalez versus Wright, was the cultivation of marijuana for personal use, no economic transaction involved, because that could affect the actual market for marijuana. That was enough. That echoed a decision made during the depths of the Depression in Wickard versus Filburn. That's very clear. As for the statement that's being made that Congress has never before required any sort of economic purchase by individuals, that is refuted very directly from the very first term of office of our first president, President Washington, who in the Second Militia Act of 1792, Congress passed a law that required every individual who was going to serve in a militia to purchase a gun, ammunition, a knapsack, and gunpowder, requiring that purchase in order for them to be properly turned out if they were called into service by the federal government. So those issues do not have merit. The 10th Amendment issue appears to be a claim that because the federal law involves establishing insurance exchanges in the states, that is a commandeering problem, which is an issue that's arisen in some cases over the last 20 years. But the federal law does not require states to set up insurance exchanges. It gives them the option to do so. If they do not, then the federal government will take the responsibility of setting that up in a given state. So there is no commandeering, and I think the 10th Amendment argument also fails of its own weight.